Greetings and salutations, and welcome to another episode of the Legal Beagle podcast. Today we're talking to Kurt Benshoff of Seattle, Washington. He has quite a story, and we're only going to really scratch the surface of it today. But he has a plethora of knowledge and experience that was forced on him by unforeseen circumstances that we'll get into today. But I hope you enjoy this as much as I did. And without further ado, here's Kurt. So welcome, Kurt, to the Legal Beagle channel. And I see that you're in full disguise today. I was going to inquire about your wig collection and sunglass collection and that type of thing first.
Well, my wig collection hasn't been on full display yet. This isn't actually a wig. This is what's called a harf in the fashion industry. It's a combination of a hat and a scarf.
I got it. And why would you be wearing something like that?
Well, it depends what the setting is. In the courtroom, I go with different looks just to fuck with their heads. Because, you know, I live in woke Seattle, and because I'm a white male, they wanted to put me in this category that, I must be a white male Republican, MAGA, transphobe. And so if I show up in wigs and mascara and eyeshadow, then it kind of, and if the wig is blue, it really messes with them.
And so for a little more clarifying question, but why, can you give a brief history of why you need to disguise yourself at this point?
Well, I actually don't. Well, no, it's true. I'm basically on house arrest, and I have been for about a year, because I started getting arrested for the non-crime of grocery shopping without a mask back in 2020, which was comical because the Seattle police, they had police officers in their department that were defying the mask orders, which technically they were supposed to comply with because as part of their employment contract. None of the police officers who refused to wear a mask were even disciplined, let alone charged with the crime. And yet other police officers who did wear masks would come around and arrest me. So that led to family court, and my son's psycho mother accusing me of being a crazy anti-masker criminal scofflaw. And then my son was kidnapped on September 3rd, 2021. And then when I tried to text my son to keep him from committing suicide, they said that I was committing domestic violence. So currently there's 10 warrants, all bogus, out of Seattle Municipal Court, and a total of $360,000 in arrest warrants.
Jeez, man.
So
the authorities kidnapped your kid, not some mysterious.
Well, it was to make this as Jerry Springer as possible. A prostitute girlfriend. I mean, technically they're high-end escorts, but my son's mother is also a high-end escort. And on September 3rd, 2021, while the police were watching, she stole my car and kidnapped my son inside, and I've never got him back. And while most people would think, well, how could that possibly happen? The reason that there was motivation for the city officials to throw the book at me was that after my first maskless shopping arrest on September 11th of 2020, the next day I emailed the city attorney, Peter Holmes, and I let him know that I would sue him personally for $10 million if he didn't have the police stop harassing me. So I think there was maybe an incentive to try and squish me and get me to shut up, but they didn't do their opposition research.
And so give us a brief overlay of what all actions you've taken to get to where you are, a brief. I know that it's quite in depth, but went from municipal court. Did you go into state court, federal court, and where are we at now? Appellate court.
I've been in every level of state and federal court there is. And I started at the bottom and I climbed the ladder.
And as these people violated your rights, you had to add complaints and add them and move on up the chain. And now you're probably in the Ninth Circuit Court of Appeals with all of your stuff, or where?
No, I only have one case in the Ninth Circuit right now. So, the city, there's 10 current cases, criminal prosecutions in Seattle Municipal Court. As most viewers probably realize, the municipal courts, you're not going to get any justice there. It doesn't matter what you do. And you know, I tried the next higher court here is King County Superior Court. I tried 4 writs of prohibition to stop the malicious prosecution in Seattle Municipal Court. Those all were denied, which, you know, basically no judge wants to be the one that rules in my favor, because it would be like pulling on that one loose thread on the sweater and the entire corruption would just fall apart. So those 4 writs of prohibition that were denied, I'm appealing those to the Washington State Court of Appeals Division 1. And, you know, at some point I realized I'm just not going to get any justice in the state courts. Because when they took my kid, I tried writs of habeas corpus in King County Superior Court. I tried one in the Washington State Supreme Court. I tried one in federal district court. They denied me under domestic relations exclusion, even though there were no domestic relations. And I caught the Ninth Circuit doing the same bullshit argument. And then I took a habeas to the Supreme Court of the United States, and they didn't choose to hear that. But as far as getting remedy and trying to stop the criminal conspiracy in the city, I filed a federal lawsuit in September of 2022, suing City of Seattle, King County, a number of stores that had, basically conspired with the police to unlawfully arrest me, and a number of attorneys at different law firms, my son's mother, her girlfriend, and so that's an ongoing case in federal district court.
And so you're now basically prosecuting a RICO trial against all the courts and judges and of Seattle and Washington.
Yeah, my complaint includes RICO, and I'm suing 6 judges, which is almost all of them out of Seattle Municipal Court. I'm suing the family court judge out of King County Superior Court, and yep, we're having some fun.
A lot of people would not call this fun, but there is moments that is fun.
Yeah, I mean the first 2 years was absolute hell, because unless you're a parent who has lost their child and then known that you basically can't do anything to protect your child without getting arrested, it's a very emotional experience, because no parent wants to know that their child is suffering. And so it was very frustrating for the first 2 years. I'm not going to lie to anybody and say that this has been roses the whole time, but I have to say 2024, I've been having a lot of fun, because, I just feel like I'm getting close to the finish line. Somebody's going to break. I'm just bringing too much heat.
Right. And let me just say, you are one of the sharpest guys in our Telegram chat, and you have been forced to learn so much that you have a lot of knowledge and experiences to share with us that could help others avoid some of the pitfalls that I'm sure that you have fallen into and had to climb out of?
Yep. Well, that's the best way to learn is to, get in trouble and have to get yourself out.
Sure.
And for anybody that's watching, like, you don't have to have a college education, you just have to have the desire to learn. I mean, I was poor trailer trash growing up. Like, I was part of the 1/3 of 1% in my high school that lived in a park. I didn't get a college education. I spent a bunch of years running my own remodeling business, and then I was growing cannabis, right? Like, I was just a nobody, just being stay-at-home dad. And but once I had to, basically I got forced into learning the law because no attorney in Seattle, and I called a lot, would take my case because no attorney had the balls to start suing judges, and I could tell that's what needed to happen.
Mm-hmm. All right, well, let's get into what's currently happening. We can do a separate episode with some backstory later, but I think we have enough to go on to start hearing some of the technical difficulties or details, however you want to say. And you start. Tell us what you want to talk about.
Okay, so the three most exciting things going are, I have 2 federal lawsuits in the Western District of Washington, and then I have an expedited appeal in the Ninth Circuit. And so my primary lawsuit, which I mentioned earlier, against the city of Seattle and King County and the others, the judge in that is definitely very prejudicial. And I discovered he's the newest judge here. His name's Jamal Whitehead, and he's your prototypical woke leftist. And so he's protecting the liberal woke leftist system here, which we have it in spades. And so he's basically denied every motion that I've filed. And he literally calls my motions frivolous and threatens me with sanctions. And one of the exciting things is I did some research on this guy, and he was appointed. Let me back up. He became a judge in 2023, but the prior year there was a commission set up by the 2 Washington senators, Maria Cantwell and Senator Murray, to find a judge that would be good for Washington. So one of the 6 people on that commission happens to be the former mayor of Seattle, defended a lawsuit, Jenny Durkin. But
Can you say that one more time?
Yeah. So one of the 6 officials here that voted to have my Judge Whitehead, get appointed is the ex-mayor of Seattle, Jenny Durkin. And Jenny Durkin also happened to be a defendant in my lawsuit. And the coincidences continue because Jenny Durkin, before she was mayor, was the U.S. District Attorney for the Western District of Washington. And she was actually under consideration for replacing Eric Holder. She's comes from a family of well-connected politicians. So in 2014, she was the U.S. District Attorney, and my judge, Jamal Whitehead, just happened to be an assistant U.S. Attorney in 2014, right? So the connections, and I could go on, like
all coincidences, I'm sure.
Yeah. And so what I did is I filed an emergency temporary restraining order a couple weeks ago in U.S. District Court. And I'd filed temporary restraining orders before, trying to basically stop everything at once. And I decided to narrow my focus on the issue that was essentially impossible to rule against. And that was, I just wanted injunctive relief to stop the city of Seattle from continuing to prosecute me 3.5 years later for shopping without a mask. Because the short and skinny of that was that the grocery stores would say, put on a mask. And I would say, well, that's against my beliefs and I have a disability. And they'd say, well, Mr. Benshoof, how about a face shield? You can do that. And then I would point out that the Washington Department of Health had stated on their website, which of course I screenshot back in 2020, that a face shield does nothing. And the Washington Department of Labor and Industries said the same thing on their website in 2020. So I established my case back in 2020 by GoPro video recording me explaining this to the police, to the prosecutors, to the stores, that your mask policy is arbitrary and capricious because you're offering interchangeability with an EUA device that, if you're following the state guidelines like you say you are, it does nothing. So let's stop the clown show. And I thought that restraining order.
So
let's
talk about EUA device real quick. Can you
Sure.
briefly tell the audience what that is and what the limitations the government are required to impose on themselves regarding EUA authorization products?
Well, now you're going to put me up against Brandon's expertise, and I'm going to sound like a clown. But I'll give you the short version is that EUA stands for Experimental Use Authorization, and that can, sorry, Emergency Use Authorization. See, there you go. What do I know?
That's okay.
And that can apply to products like gene therapies. That can apply to devices like masks or face shields, and they're emergency use. So under the PrEP Act,
and the shot.
Yeah, well, right. I said gene therapy products. I wasn't going to say vaccine because under Washington state law, RCW 72.290.010 subsection 10, we actually had the definition for vaccine, and it did not include the gene therapy products from Pfizer. And coincidentally, the state of Washington just passed a bill to change the definition so that vaccine under Washington law includes anything that the CDC recommends. But too late for them because I already have all that in my federal lawsuit, and that doesn't help them. So with the emergency use, they can offer the product or device to you, but they can't coerce you to take it. There can't be a penalty for declining the offer.
And they have to give you the pros and cons of the EUA products, right? They were required to do that under the 2005 PrEP Act, I believe. So, which was a result of the military trying to force the
anthrax in Iraq
vaccine on all the military. And so the PrEP Act was made in subsequence to that to protect the military and whoever didn't want to take experimental drugs, and no one can force you to do so. Continue.
Well, that's by and large true, but I do have experience with being handcuffed, strapped to a stretcher, and 4 police officers forcing a face mask onto my face so that they could wheel the stretcher into a hospital to do a forced blood draw because they accused me of being high on drugs for standing in an empty parking lot trying to report crimes. So you just never know.
Hey, they're wacky out there on the West Coast, man. You never know.
Yeah. So having been arrested a number of times, for anybody that ever might find themselves in that situation, my policy is always smile, always be polite, and there's no reason to resist. They're going to do what they're going to do, and you will get your justice later. And just remember that everything you do or say can and will be used against you. And so since that stuff's usually being recorded, you're playing for the jury in the future. And if the jury later sees that the body-worn video shows that you were smiling and cracking jokes, they're going to have a hard time thinking the police were reasonable.
I think that's a very good piece of advice.
Yes, hard-earned.
Hard to do probably, but it comes with peace.
Yes. Take the high road.
Always.
So where were we in?
I believe we
what
were.
Do I need to talk?
You were suing the judges in the King County Court, and
yeah. So with the, I was talking about that I filed for a temporary restraining order, which I really like because it fast tracks it. Like we're talking hours, not days,
right.
So, which is under Federal Rule of Civil Procedure 65B. So I had sought this TRO, trying to stop the city from prosecuting me for not wearing a mask, because for those cases, there's $45,000 in warrants, and I literally can't go anywhere. I can't go into a grocery store because they all know me. I can't go anywhere. And I thought that was a no-brainer because my judge is black. If you look at his bio, he's supposedly respects Martin Luther King and the Civil Rights Act. And he's even disabled. So I thought that if I pleaded the ADA and the Civil Rights Act, how could he possibly deny that? Well, it was very simple how he denied my restraining order. He simply stated, the grocery store trespassed you, and the city has a right to enforce its trespass laws. And with those two one-line tautologies, he denied my 38-page temporary restraining order. Explain to any viewers that aren't familiar with the trespass law, the reason that those two tautologies from Judge Whitehead were so ridiculous is that it's based on the premise that a public accommodation, when they say, when they hand you a paper that says trespass admonishment, that's a civil claim. That's no different than if you handed to the grocery store a notice of claim and opportunity to cure. It has no legal authority to do anything unless you were to actually take that into a civil court and file a lawsuit. And of course, the grocery stores did not follow up their civil trespass admonishment by bringing a claim in civil court. Instead, what happened was they called the Seattle Police Department, and when the officers showed up, they said, "Well, PCC trespassed you. If you come back, you're going to be arrested." And no matter how many times I explained to them that civil trespass admonishment cannot magically convert into criminal trespass, because that would be a violation of the Equal Protection Clause of the 14th Amendment, because it would be bringing the authority of the state to intervene and take sides in what was a civil dispute. And so the second tautology from Judge Whitehead, that the city has a public interest in enforcing and prosecuting its trespass codes, of course, was premised upon the first tautology, in that while of course the city has the authority to prosecute violations of its codes, but there was no violation of the code because I never trespassed anywhere.
And the elements of trespass are not such, and they don't conduct it in a way that is lawful, right?
Right, because I had to have knowingly entered or remained on the premises unlawfully. And so the two elements there, the mens rea and then the unlawfully. And so, it's an impossibility that they could claim that I was there knowingly in violation, because I had been recording myself explaining to them for months that I was there in full compliance with all the proclamations, all the laws. And then, the element that the police would essentially say, well, we told you to leave. We told you that you were trespassing. That's a lawful order. And if you violate a lawful order, then you're there unlawfully.
And did the cop sign the citation for trespassing, or did they get a signed complaint from the owner of the property?
Well, that's more of a granularity question. Without getting into too much detail, there is a statute and a declaration form that a representative of the establishment is supposed to fill out and sign under penalty of perjury, which they then give to the police to grant the police authorization to remove somebody from the premises. But, if you read through that, a public accommodation cannot do that, because one of the conditions that the signatory is affirming under oath is that the establishment was not open to the public at the time that it had occurred. And if you dig into it, what this declaration form is really for is for a situation where it's a private membership club, or it's a condominium where somebody is somewhere on private property, not open to the public, where they're not supposed to be. I tried to explain that to the cops as well. And next thing I knew, they threw me to the ground.
So did you have any injuries during all these arrests?
Oh, minor. I played a lot of basketball, so I was always good at falling down without getting injured too bad.
All right.
No, other than some scrapes and bruises, that's typical if, somebody throws you to the ground on pavement. But no, nothing serious.
Okay.
It was all good fun.
And so where are we at with the prosecution, or your prosecution of these events?
Well, so just to follow up with Judge Whitehead denying my temporary restraining order a couple weeks ago, I had written that temporary restraining order knowing that I might need to take it to the Ninth Circuit. So I tried to do a really good job getting the case law in there and everything, and making sure that I had all of my arguments, so that if I needed to go to appeal, I already raised every possible issue that I could want to raise. So I, as quickly as possible, filed a petition for discretionary review, sort of interlocutory appeal with the Ninth Circuit, and I had 19 abuses of discretion under both errors of fact and errors of law, which in the Ninth Circuit, it's U.S. v. Hinkson at I think 1263, where they break down what the Supreme Court has established as meeting the definition of either an error of law or an error of fact. So I had 19. I thought that was probably pretty good, and
a lot more than most appeals.
Yeah. And so I used up all my 13,000 words to file an 80-page petition for discretionary review. And then what I did in conjunction with that to fast track it was I filed a contemporaneous, literally the same day, like a few minutes later, I filed an emergency motion seeking expedited review of my petition for discretionary review, which is under Federal Rule of Appellate Procedure 27.3. It's very handy. And the reason that I did that 1-2 combo is the other option I had was I could have simply gone to the Ninth Circuit and filed a new temporary restraining order, but my word limit, I would have only had 5,400 words instead of the 13,000 with an actual appellate opening brief. So I chose to use my full 13,000 words because I really needed to get all the facts and the law in there, and then I'm fast tracking it with the emergency motion.
Gotcha.
And so if that's normal, but that was the tactic that I came up with. And the current situation on that is the city has filed their response. The grocery store has filed their response, and I got a couple days to file a reply, and then hopefully I'll get a quick ruling. And the one other interesting tidbit that's come out of this appeal to the Ninth Circuit is the couple orders that the Ninth Circuit has issued. They titled it as Mr. Kurt Benschoof. And I mentioned this to Randy last night. I called in. I'm like, have you ever seen that? Because everything I've seen from the circuit courts here, it's like they just write your name. Nobody ever writes Mr. And on my documents, when the court issues orders, there's other individuals. They don't put a prefix before any of their names. And I asked Jill Bong. She's like, I've never seen that. So the best I can come up with, because I'm an optimist, is the Ninth Circuit judges are aware of the validity of my case. And as I said at the start of my appeal, this is the most prolonged subversion of the Civil Rights Act in Washington state history. So my hope is that they're calling me Mr. Benschoof to let the appellees know that you need to start treating Mr. Benschoof with some respect.
Yeah, hopefully it's a sign of respect. Absolutely.
Yeah.
Because you are, there's a lot riding for them for sure, and definitely for you on the outcome of these things. And I would not doubt if the Ninth Circuit is not beneficial or favorable to you, that the Supreme Court would probably look at this, because it's such an unbelievable, gross violation of rights across the board.
Yeah.
I mean, with the RICO, and I mean, it puts our middle district, conspiracy to shame compared to what you're doing.
Yeah. Right. Yeah. And the reason it's so egregious to me is this wasn't just one or two public officials who misinterpreted the law for a month or two. This is massive in scale, and it's gone on for 3.5 years, and they just keep digging their feet in and arguing against the Civil Rights Act. And, that's why I tried to quote heavily from the petition that was brought to the Supreme Court in the Roman Catholic Archdiocese v. Cuomo, is if for some reason, because that was an injunction that that the Supreme Court granted back in 2020 regarding the New York City mask mandates on religious grounds. So I made sure to quote from that in my appeal to the Ninth, just to telegraph to them, hey, I've already read cases that the Supreme Court has granted, and the Supreme Court granted them at the height of the insanity in 2020. So if you're going to deny me, well, under 28 USC 1654, I can go straight to the Supreme Court with an original jurisdiction petition for temporary restraining order and fast track that right up your ass. So do you want to be the circuit court that rules against the Civil Rights Act? Be my guest.
Yeah. Well, I'm not sure any of them. I don't know. I don't know what to say after seeing and experience what I've experienced. But,
right.
But here's hope.
Yep. Well, expect the worst, plan for the best.
That's right. That's absolutely.
Expect the best, plan for the worst.
There you go. So how many motions or documents do you think you've written in the last 3 to 4 years?
Wow. I mean, hundreds. I've written thousands of pages.
Yeah.
I mean, it would be funny to find out, but I don't have the time or interest in going and counting, but it's ridiculous, right? I mean,
That would be a
And
waste of time at this point.
yeah, and something that people who are newer to the process might take comfort in is it gets easier for a number of reasons, and them a big one is that once you've written a bunch of documents on the same issues, you can cut and paste large sections of your own work. And so, that's part of how I'm able to crank out so much volume as one person is I've been arguing these issues for 3.5 years. So I've got so many documents to choose from, like cut and paste there, cut and paste there. And, I think it's a good psychological tactic when you're litigating against a half dozen law firms is to outproduce them by yourself.
Yeah. Yeah. And it takes
Like,
them.
how's it going, guys? Having fun yet? I'm having fun.
Yeah, the thing about lawyers are they get paid to do this, so
Yeah.
they don't care as much, right? And
Mm-hmm.
it's hard to motivate yourself as a lawyer to care about someone else's problems. And so you leave some little details out and this and that. But when you are personally invested in things of this, and not only do you know all the elements of the case and every detail, when you write, it's firsthand personal knowledge, whereas the attorney is all using hearsay to argue against you. And rarely do they put any facts on the record. Have you had any facts on the record from opposing counsel yet?
Some they will. I've had a number of attorneys write up declarations as attached documents to motions, but if you actually read through their declarations, they're nothing burgers. They're citing to other documents that I've filed, to try to disparage me as, oh, look, he's a vexatious litigant because he filed all of these things. So, or they're just stating facts. They're nothing burgers. So yeah, your point's a valid one.
Mm-hmm.
Mm-hmm.
So where can we go from here?
So the other lawsuit that I have going. Oh, actually, no, I want to touch on my the restraining order that I filed after that one, because this gets into hard evidence of judicial corruption. Probably the best evidence I've come across yet, at least in my scenario. And I have a lot of evidence of judicial corruption. So to backtrack a little bit, the very first lawsuit I filed was in King County Superior Court back in the fall of 2020. And that was I should post it because it's such garbage, right? But it's a learning process. So that lawsuit was trying to address the fact that my son's mom and her girlfriend and the family attorney had used the family court system in an abusive process. And for those who've never pleaded abusive process, I didn't really understand it when I started out either. An abusive process claim, at least in Washington, it's not claiming that the initiation of the legal action was invalid. It's that after the case was initiated, there's evidence typically involving coercion where the defendants have engaged in coercive activity, such as extortion, that's related to the initial action that was filed in court. And so to give the example in my case, my son's mom, her girlfriend, they stole my car, right? And they kidnapped my kid inside. And then they got the family attorney to file a parentage action in family court to assert that the family court had jurisdiction. And essentially the parentage action claimed, we don't know who the dad is, even though I've been his dad his entire life. There in the delivery room. I was there when he was conceived, even. Imagine that. So I wasn't attacking that the parentage action was barratry. I was simply claiming that after they filed the parentage action, that the family court attorney said, hey, you can see your son 8 days a week. And at the same time, my son's mother and her girlfriend messaged me saying, hey, you can have your car back if you give us $19,000. So that's an example of they're engaging in coercive behavior, i.e. extortion, which is a Class B felony here. And it's directly related to the family court parentage action. And I thought at the time that that would be the polite and safe way to go, because I wasn't claiming that the family court was totally corrupt. I was working on the presumption that, yeah, I was basically going, hey, I'll respect that the parentage action was valid and all that. But after they initiated that action, there was abusive process. And what happened was the family court judge, of course, has some buddies in King County Superior Court. And one of his buddies is a judge named Marshall Ferguson, who is incredibly corrupt. And he was assigned my lawsuit for abusive process. And he immediately dismissed the case and issued an order that I was a vexatious litigant. And what happened was, at this hearing on January 26th of last year, they refused to let me appear in person because I wouldn't put on a mask or face shield. So then when I tried to log on to the Zoom, it wouldn't let me log on. And I've been on dozens and dozens of Zoom hearings. It's the only time this has ever happened. So it took me about a half hour until I gave up trying to log on Zoom from multiple computers, and I called in. And I didn't know until later, but the judge had been engaged in ex parte communications for those 30 minutes while I wasn't on the hearing. And of course, when I finally appeared by telephone, they didn't tell me they'd been talking about law. They didn't give me any sort of recap. And in fact, they conveniently omitted the law, the statutes and the case law that they were discussing before on the phone. They never mentioned it in the entire hour-long hearing afterwards. It's like they just, so it took about 4 months for me to get the transcript. And what I found was that it wasn't just ex parte communication talking about the Seahawks or, talking about how they thought I was a jerk. The judge initiated the ex parte communication and told the 3 attorneys that the judge names Marshall Ferguson. So Ferguson told the 3 attorneys, who were experienced attorneys, that he had concerns about their motion to try to silence me and dismiss my lawsuit under the Uniform Public Expression Protection Act. We call it UPEPA. In some states, it's called the Anti-SLAPP Act. So the judge said, hey guys, I have concerns about you claiming UPEPA protection for your 4 defendants. Have you looked at this one case called Kuhlmeyer? It's a recent unpublished opinion, because Kuhlmeyer cites a new act from the Washington legislature called the Abusive Litigation Act. It's under Title 26. And when you read the transcript, you see the attorneys saying, yeah, we looked at that, but we didn't think it applied. So the attorneys knew that RCW 26.51, the Abusive Litigation Act, didn't apply to me. But the judge took the time to reassure them that Judge Ferguson thinks it does apply, and it's probably better than claiming UPEPA because, wink, wink, I'm bringing the idea up. So obviously, if you file under RCW 2651, I'm going to approve it because I brought it up. Like, this is, I don't know if I'm more shocked that it's this corrupt, or that they would be stupid enough to discuss this on the record, right? The only reason I know about this is because everything they said was on the record, which means once I got the audio, I could have it transcribed. Like you must be so confident that you are above the law that you will just commit fraud on the record. Either that or you're fucking stupid as shit. Maybe both. So, and the reason that, so beyond this ex parte communication and beyond the fact that he's sua sponte giving legal advice, which he's told me he can't even answer my questions because it might be legal advice, right?
Yeah,
Double standard.
The clerk loves to use that excuse.
Yeah. But the really shocking and the truly fraudulent part is if you read who this statute applies to, RCW 2651, the Abusive Litigation Act, it is specifically only for situations where a court has found one person to have committed domestic violence against the other. So if any court had ever said, yes, Mr. Ben Shoof, smacked his son's mom, then they could use the Abusive Litigation Act. But the definition of abusive litigation requires that. The statute where you can where you can file a motion requires that a court has found that. And if the court has found that abusive litigation has happened, Judge Ferguson was still required to set a hearing and hear all testimony, which he didn't do either. So when I say this court went over the top on the fraud, I mean it. And how that gets us up to the current events with the most recent restraining order in the U.S. District Court is I was just letting that whole shit show of fraud that happened before Judge Ferguson a year ago, I was letting it slide. I actually removed him as a defendant when I amended my federal lawsuit. I'm like, maybe he's not that corrupt. I'm just going to give him the benefit of the doubt. Maybe he'll, rule on my favor with my writs of prohibition if I play nice. No, what happened is these same corrupt attorneys that he gave the advice to, when I sued them in federal court, they went running back to Judge Ferguson and convened a hearing and asked Judge Ferguson to sanction me for violating the order restricting abusive litigation. And so we had a hearing on February 29th. And of course, I filed all the briefs explaining how it's absolute fraud. But in my briefs, I put all the blame on the corrupt attorneys, right? I knew that Judge Ferguson was in on it, but I was giving Judge Ferguson the opportunity to put all the blame on the attorneys so that he could wash his hands of it. It was clear what I was doing, right? But at the hearing, Judge Ferguson started out the hearing by letting me know, and everybody know, that he wasn't going to hear any arguments from me about my underlying claims that his original order last year was invalid. He was only going to hear arguments about whether I had violated it.
But only if you're guilty can you come here and talk about it.
Yeah. And so I started talking, and my idea was, first off, I said, thank you for being forthright about your prejudice before I started talking, Your Honor. And then I was like, well, since I'm going to have an opportunity to get a transcript of this hearing, I am going to, for the record, explain as much of the fraud as possible. And, he tried to interrupt me, and, he tried to shut me down by saying, I didn't even have to have this hearing. I convened it so that I could hear arguments from both sides. And I said, Your Honor, that is true. But once you decided to set this hearing, I have an equal right to make my arguments, and I get equal time. And I would prefer if you don't interrupt me, because I am going to say what I want. And I proceeded to speak as fast as possible, putting as much evidence into the record for the next 25 minutes. And
I think I tuned into that one for a little brief
and
moment.
So just to show you how stupid and corrupt these people are, right, because I was letting this whole thing I have so many claims, it wasn't even in my lawsuit.
And stupid is the key here.
Yes.
They just do not know when to stop.
Yeah.
They think they're guilty, so we might as well go all the way. Might as well commit murder. These people are crazy. They're crazy.
They are batshit crazy.
Yeah.
So they're the idiots that issued an order for sanctions and potential jail time on February 29th. Well, that basically brought a dormant issue into a live controversy, because that order that they issued on the 29th gave me 7 days to comply with their order, or I was facing arrest. Well, guess what? That meets the definition of grave, immediate, and irreparable harm, the threat thereof, to qualify for a FRCP 65B temporary restraining order. So I sent a thank you email to all the corrupt attorneys and judge saying, thank you so much for giving me the opportunity to file this. And so I filed that, and the judge has yet to rule on it. And this is uncharted territory, because the response time, as I said earlier, is a matter of hours. If you're in state court with a temporary restraining order, the judge has to either grant or deny it at the hearing. In federal court, it's more like 24 hours, because they're trying to do a better job. But the response was in on Thursday, and the judge never denied or granted the order yesterday, which I think this is a monumental shit show. And my guess is that Judge Whitehead he's got a few options. I've put so much evidence on the record of his corruption that I think he's taking a hard look at whether he should recuse himself from this case. And because he has the Ninth Circuit breathing down his neck on my mask appeal, I think I've cornered him in that.
And this is a state judge?
No, this is Whitehead.
Judge.
Whitehead's my U.S. district judge with the lawsuit.
Okay.
Yeah, so Whitehead is the one that denied my mask temporary restraining order that's at the Ninth Circuit. And it's Whitehead who has this other TRO regarding the judicial fraud from King County Superior Court. So I think he's in a pickle. And if he was just going to deny it, I think he would have just done his usual denial and said, Mr. Benshoff's a vexatious litigant. He would have done that on Friday, but he didn't. Mm-hmm. So I think we're getting close to some epic fun.
Well, I can't wait to see it, for one. We've cornered our Western District judge to a point. He was ruling on a few things, but that's since completely stopped. It's been close to 300 days that the motions to dismiss have been finalized. Won't touch
That's
it.
Crazy.
We put in summary judgment. Won't touch it. We put in all the TROs we know to do, and at this point it would be duplicative, so we can't resubmit any. And so
were you guys doing actual TROs, or you're doing preliminary injunction?
Yeah, okay. Injunctive relief. Yeah.
Yeah.
And the only one he granted us only one was giving us e-filing privileges in the Middle District. And we had to sign up as lawyers because the Middle District has no mechanism for a pro se to file e-file. And they were hot about it, I can tell you. But that's the only relief he's given us because the clerk was holding our filings for 11 to 13 days and changing the rules of the court behind the curtain in order to, make it seem like this is all moot. No problems here. But
right.
Good grief. It's just unbelievable. And that's just a small sample of what you've gone through. I mean, just.
Yeah. And that's, the reason that I went back to the TROs was because of you guys, right? And I think you might have even, or Brandon mentioned that on the phone, was that, just that's the way to go through the appellate process faster than normal, right? And
it is
so then when I revisited, and so when you guys reminded me of that, because I'd tried injunctions and TROs in U.S. District Court last year, right after I filed the lawsuit, and the judge just denied. And so I gave up on it. But then,
so let me
when
ask
you guys were,
when he denied it, did he give you findings of facts and conclusions of law with them?
Yeah, and they were all bullshit.
Well, so that was our issue, right? So the judge just said no. He didn't provide anything according to Rule 52. So we spent our time giving the judge the benefit of the doubt, filing a Rule 52 motion, trying to evoke conclusions of law and findings of fact, because we thought it was required for the appeal. And so you only have 30 days to appeal that injunction ruling. And so waiting on him to respond to the Rule 52 motion, that time expired and we missed our window to go to the Fifth Circuit. So that's why we're sitting here and he's just doing nothing.
Right. Yeah, and that's what they do when you corner them, is they go silent and they play delay a game.
Yeah.
And that's where the injunctive relief kind of gets passed, because of course I have motions before Judge Whitehead that have been sitting there for months. I mean, because I had essentially every person who acted as a process server for me got threatened by different defendants, and the police would do nothing. I tried, and that's after somebody paid off the process server firms in this town to not take me as a customer.
You got to be kidding.
No. Oh, no. Trust me. I called around and nobody will do business with me. And
no
of course,
lawyers, no process servers, no.
Right. And now I'm not just paranoid, because there is one company that I dealt with before. They'd run dockets, they'd run documents to file for me. They were super helpful. And after I filed my federal lawsuit in September last year, then when I called them up, they said, "Oh, we're slammed this week. We don't have time." So then I was like, "Well, how about next week?" And they're like, "Oh, we're just booked." And so I called an attorney friend, an actual attorney who's good and a friend. And I was like, "Hey, can you have your paralegal just, see if you can get this this place to take your business?" Oh, they'd take their business same day, right? So I wasn't imagining it. Yeah. Everybody was just too busy to help me. So then I was like, wow, I've really scared some people if they're going to those lengths. They're trying to stop me at every... And so because of this, I took a motion to Judge White District Court, and I said, hey, the police won't do anything about my process servers getting threatened with baseball bats, you name it. Clearly there's a conspiracy so that I can't hire a process server even if I could afford it. here's my motion requesting that you direct the U.S. Marshals Service to effect service, because in the local rules here, they don't normally just let you use the Marshal Service as a
Right.
pro se informa preparis. So I
Only
filed the
if
motion.
you're, what, serving the government, mate, or something like that.
Yeah,
There's some special, yeah.
And that motion, simply requesting service by the U.S. Marshals, has been, it was an unopposed motion, which under our local rules means I got to note it for the same day. So that motion has been sitting there for 2 months. 2 months.
That's great.
So,
that's great.
You know, the thing is when you see judges do this, you just got to get at a point where you laugh at them, because it's like, you little bitches are so desperate that you're like, on the record, you are petty ass little punks. And like anybody watching can see how desperate. Yeah.
So,
and you know,
do you have any more details you want to talk about, or can I ask you some fun questions?
Oh yeah, sure. Fun questions. How did I have a kid with a prostitute?
No, nothing personal. Nothing personal.
Okay.
Yes.
Well, just for the record, that I didn't meet her in her work.
Okay.
I was doing hardwood floors back then, and she went to carpentry school.
Hardwood
and
floors, you say?
Yes, sir. It was Brazilian cherry hardwoods, 3/4 inch thick by 3.5. And she volunteered because she wanted to learn how to lay hardwood floors. There's lots of puns in there.
Absolutely. So, describe one of the most interesting conversations you've had with a lawyer, opposing attorney. I mean, in one of these cases.
Well, the most I'll bring a couple. So one of them I haven't even had yet, in a way. So I'm suing a chain in the western states called Big Five Sporting Goods, and I hadn't even served them yet, but they hired a major law firm here, and one of their partners appeared to represent them. And so I immediately emailed Mr. James Yand, and I said, hey, if your client wants to settle, before getting into litigation, now is the time. And he emailed me, and I let him know that I have lots and lots of video of, store employees threatening violence against myself and my African-American female friend, which really isn't going to play well here on the West Coast. And he emailed me back this week, and he is like, hey, would you like to meet informally in person for coffee? And I was like, is this normal? Do partners of law firms offer to meet pro se attorneys for coffee?
I was like, is it normal?
I don't know. I mean, this week has been weird. It's like, first I'm Mr. Ben Shue from the Ninth Circuit, and now attorneys are inviting me for coffee.
That's interesting. Probably because they want to know what you know.
Maybe, yeah. I mean, I'm considering all options. You can't trust attorneys.
No.
For all I know, he's working with the Seattle Police Department, and they're just going to try and arrest me if I show up at the Starbucks. So,
yeah, good point.
Yes, but
send a surrogate.
Yeah,
with a FaceTime phone.
Exactly. My doppelganger. I've had a lot of good conversations actually with the city of Seattle attorney. He's really the only attorney I like at all. I mean, he still talks like a shyster in oral arguments. He still makes all the shitty arguments. He plays dirty in that way, in that he's an attorney. But I guess he's helped me see things as not so black and white, because I've spent hours talking on the phone with him over the last 6 months, and he's a bit of a law nerd like us. Yeah, he is a law nerd, right? He's most passionate about the rulings in the circuit and Supreme Courts. And even though Jill Bong tells me not to trust him and not to like him, and he's just a shyster, I've talked to the guy so much that I see that there's a gray area with some of these attorneys, right? Like, he would probably get fired if he didn't play the game like he's playing it, because that's their employment contract. And the dude isn't a good enough actor to be bullshitting me for this many hours of us talking on the phone. He doesn't even have to talk on the phone with me. None of the other attorneys will even answer, right? And every time that I've asked him, hey, can I file this motion unopposed so I can file it today? Every time he said yes. And when we've had issues about service, he's like, Mr. Benshoof, you've been more than forthright with me. He's like, I'm not going to waste anybody's time with nitpicking over service issues, right? So I just want to remind people out there that all attorneys aren't bad, and even the ones that still talk like shysters in court, they may be reasonable people if you just talk to him directly. And he won't respond to me in emails. He won't like have any of these reasonable conversations where it's written down for a public records request. But if we're on the phone, we're laughing, like literally like cracking jokes, So
That's amazing, because there is no opposing attorney that wants to even speak to me for more than whatever however long they have to me to ask the question and them to answer it, they're ready to get up the phone. There's no how's the weather, none of that. They're either so mad or I don't know, but they're lawyers, they're not the ones paying the bill. I mean, they should be social, but even the one that bragged about I claim to be social and non-adversarial with everyone, but that's what it says on our website.
Right.
But I called and talked about the weather, and she's like, what's your question?
Right.
So
right. Oh, actually, and to give one more example, his name's, or I don't want to say his name, just I don't want to get him in trouble for being reasonable. So with these 4 writs of prohibition that I had filed against the city to stop the malicious prosecutions, I'll call him up ahead of time, and I'll tell him what my arguments are going to be ahead of time. I'll even give him case law, because as I tell him, I'm like, I want you to bring your best arguments, because I want to win on the merits and I want to defeat the best you can do. And he's like, Mr. Benshoof, I'm going to be frank with you. You know more about family court law and criminal statutes than I do. He's like, I read your first brief, and I went, because he's in the civil division of the city attorney's office, which it's split in half, civil and criminal. He's like, I went over to the criminal side and started walking around and asking the prosecutors if it's true that the policy and practices of the city prosecutors violates the state law that you say it does. And he's like, I went over there, and he said that he went up to the attorneys, the prosecutors, and he would say it this way: am I just stupid, or is this actually what you guys are doing over here? and he goes, Mr. Benshoof, that's what they're doing over there. So, yeah, I think he's just kind of amused because, I'm making arguments that he appreciates in his nerd love for constitutional law. And because that's his area of expertise, is complex litigation and constitutional law. And so, I think he's somebody that appreciates that I'm honest, that I'm fighting the good fight. And
So what would you say about family court, and what would you say we could do to fix it?
Well, fix it. Well, that question is upon the premise that it's fixable. No, everything's fixable.
Then that's an answer.
I had to stop and pause and consider whether I think it should be abolished or if it can be fixed. No, I mean, I think it's fixable. I mean, that's part of what I was hoping to do with habeas to the court, is because I showed in there how the family courts were asserting jurisdiction, and that they were, violating the Equal Protection Clause, the due process.
And how do they gain jurisdiction? Is it
Well,
through the
so
marriage contract, when you basically create a trust with the state giving them interest in your property, or how does it work?
it's very similar to a municipality in that, we all know that there has to be at least three legs to the jurisdiction stool: personal, subject matter, and territorial. If you're dealing with your car, your house, well, then you need an REM. But the three-legged stool there, much like a municipality, no matter how many times I pointed out to Seattle Municipal Court judges that they didn't serve the complaint, in fact, they violated state law by not serving me. And even though they didn't have subject matter jurisdiction, they just say, we have jurisdiction. It happened in Seattle. They'll just stand on that. And it's like, who's going to challenge us? And if you look at the family court forms, they're basically doing the same thing. The common verbiage with family court is, it'll list out that the parties live in the state, and that, they have a child in common, that they're former intimate partners. But really it boils down to the lower courts are just going to assert jurisdiction simply because they want to, and because it's a racket, right? And of course, it's ironic that the lower courts will assert jurisdiction where it doesn't exist, and then when we go to the federal courts for remedy, they'll say, "Oh, we don't have jurisdiction," and it's like, you just pick and choose,
right? Yeah, municipalities, they're the biggest violators of our rights of any of them.
Yeah,
I mean, just from tickets to inspection stickers on down the line, to what you're talking about. Just incredible.
But if you're shoplifting if you have a shopping cart and you're high on fentanyl and you're wearing one shoe and you're screaming gibberish, and you're loading up your shopping cart at Home Depot with stolen goods, you can run right out of there with no problem. It's like,
well, in Seattle, that's what we hear.
Yeah, I mean, it's so topsy-turvy, and then here you have an honest person, right? It's a violent, I can't lie. It's against my faith. Not like there isn't any exception to that. I'm an honest guy who's just trying to follow the law and who loves his son more than anybody in the world. I mean, me and my son are best friends, like best
how
friends.
How old's your son?
He's 14.
So almost of the age of majority to choose, right?
Well, it's 16 under Washington law. Okay. Of course, and here's, of course, another example of how ridiculous the hypocrisy is here. At 13, a child can say they want gender-affirming care. They can start hormones. They can go behind their parents' back, and the state will prevent the parents from even finding out, right? So I was going to try this angle with my son. I had talked to him, and I'm like, son, I've read the gender-affirming care statute. There's nothing in there that says that a boy cannot request gender-affirming care from his father to affirm that he's a boy.
Okay.
Because under the law, the child gets to choose who their gender-affirming advocate is, and the law doesn't stipulate that you have to get affirming care for the opposite sex. So, unfortunately, when the authorities found out that I was trying to get him to make that argument, they cut off all communication.
That's why I like you, Kurt. You think outside the box, whether it's serving Bill Gates in a lawsuit to gender affirming care. They hate when you use things like that against them. They hate it. Like the judge with the civil rights and surely he'll rule him. No, sir. No.
Yeah, that's why. I mean, I don't have to fake it that that Martin Luther King Jr. is one of my idols, right? Like, if you went up to my son today and said, "Who is one of your dad's idols?" I guarantee you, my son, that would be the first name that comes out of his mouth, because I was always quoting MLK to my son, right? And I was always explaining to my son that you can't just speak platitudes. It's like you have to live it, or the words mean nothing, right? So when I quote Martin Luther King in the introduction to my motions before African American Judge Whitehead, like it probably gets under his skin, because I love and honor what Martin Luther King did more than my African American judge. And I'm like, I'm a fucking white boy. Like, what's wrong with this picture?
And he thinks you're placating him. So
right,
you're right.
Right.
But it's just a shame. Well, let's kind of wrap it up here, and we want to get in. We have you back and get into some real details and meat of the subject now that we know who you are and kind of what your story is. But any final words today?
Well, I'm a busy man, Gary. You're gonna have to check with my agent about future scheduling.
Of course, and Paramount owns your image, right?
Yeah, no, good times. I hope this helps some people. And just my parting words were like, don't let these people get you down. You know, every corrupt act they do can be used against them. It's like legal aikido. Take that corrupt energy, dance with it, have fun.
That's it.
Let's go, people.